as at close of business on 1st of December 2025. There has been no attempt by the County Assembly to respond by way of affidavits controverting the affidavits that are on record by the 4 MCAs. None. They had that opportunity, they did not do it. And therefore, in respect of that piece of evidence, it is uncontroverted. That is the position. That is a fact that has been admitted because they had the opportunity to file their own affidavits to respond to this issue. They have not. And therefore, we are squarely within the... Secondly, and lastly, Learned Counsel has sought to seek refuge, understanding order number 1 of the County Assembly of Kericho. Let me remind him what the Constitution states at Article 181, that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified in Clause 1. Pursuant to that power, this House enacted, which, in case Learned Counsel has not read, states as follows: except as otherwise provided by this Constitution, this Act, the County Governments Act, or in any other legislation, any question proposed for decision by the County Assembly shall be determined by a majority of the members of the County Assembly present and voting. Can you be present in absentia? It's an oxymoron. When he runs and seeks refuge at standing order number 1, standing procedure, therefore the Speaker cannot run and innovate when there is a clear provision of the law. Thank you, my learned friend.
Mr. Speaker, thank you. For the record, my name is Zelma Bunuke, Counsel for the Governor. I'll address the issues that have been referred to by the other side of the County Assembly. I've heard them urge the issue of Kericho and how the proceedings of this House were concluded. It will be noted and on record that upon the proceedings being terminated, the Senate resolved to vote on the PO first before delving into the other grounds. What then does that mean, Honorable Senators? We do not have to waste time on an illegality at this space. As my colleague said, the Honorable Senators have a lot to do, and we have highlighted a significant point or question of law on the threshold. Let me take you through what constitutes of the NYAMIRA County Assembly. It has got 20 elected members, 11 of which form the part of the gender top-up, 4 in the marginalized category. That is 35. Nothing changes. I will put contexture to that while referring to the Constitution of Kenya under Article 138 on the election of the President. Allow me, Honorable Senators, to refer to Article 138, 4A, which says, in a presidential election, a candidate shall be declared elected as a president if the candidate receives A, more than half of all the votes cast in the election, and at least 25% of the votes cast in each of more than half of the counties. Honorable Senators, we have 47 counties in Kenya. Half of that, my quick math tells me that is 24. Therefore, the express provision of this, of the Constitution, is that we cannot then say that if 38 counties voted, then they did not meet the threshold, because the law is clear that they have to be more than half of it. So what you're being told here is that we need to subtract the members who are not present and then lay the basis of having the 2/3. Allow me to refer to the Constitution once again on the process of the removal of a governor. It's very clear. It is not something that has been created out of anything else. but it's in the Constitution. The framers of the Constitution were very specific under Article 33(1), and I will read Article 33(2). Sorry, this is the County Government Act, Section 33(2). It is specific that a motion under subsection 1 is supported by at least 2/3 of the members of the County Assembly. This, honorable members, is a specific motion. It is not a bill or any other motion that can be brought to the House. It is particular to the removal of a governor. We do submit, honorable senators, that even if the County Assembly Speaker sought to create his own rules on how to conduct this voting exercise, then the standing order number 1, which they have sought to rely, is very specific, and they have read selectively standing order number 1(1). What they didn't tell you is that standing order number 1(2) provides as follows: the decision made in paragraph 1 shall be based on the Constitution of Kenya, statutes of law, and the usage of forms, precedent, custom, procedures, traditions of the County Assembly of NYAMIRA, the County Assembly, and the Republic of Kenya within this jurisdiction. They have failed to refer you to any statute that provides for proxy. You have also been told that this is a norm at the County Assembly of NYAMIRA to use proxy voting. Then we pose this question, honorable senators. Should we then countenance an illegality on the face of it, which has these serious ramifications, including impeaching an elected governor on a basis that does not exist in law? Honorable senators, we urge you to consider our preliminary objection, and especially on this point on the threshold. If you are told that the issue of proxy have to be called as witnesses, that is fine. But then have we determined the first question on whether this motion met the threshold? The answer is a resounding no. We yield to that, honorable senators. Thank you.
Now, honorable senators, we have 6 minutes. Kindly shoot straight so that we can extract the most out of these 6 minutes. Senator for Nairobi City County.
Honorable Speaker, very interesting arguments have been made about membership, and I want to see clarification.
To that, honorable senators. Thank you.
Now, honorable senators, we have 6 minutes. Kindly shoot straight so that we can extract the most out of these 6 minutes. Senator for Nairobi City County.
Honorable Speaker, very interesting